Namaste, Sakshi Telugu Prajala Mana Sakshi Special Immigration Showki Swagatam. Today we are back with our expert attorney Bhanu Babu Illindra garu, BBA Law Group, PC 17 years of experience in law offices. So, if you have any queries regarding immigration, feel free to call us. Our attorney will glad to answer your questions, and also make sure that please your questions should be related to today's topic. So before we begin the show, please note that the information provided on this show not a legal advice, it's just for information purpose only. So Sakshi TV or its agents will not be responsible for this. If you need any specific legal advice, please contact the attorney directly. And Bhanu garu ready ga unnaru. So let's begin the show. Hello Bhanu garu, welcome to the show, Andy. How are you?
Thank you, Prasanna garu. Thank you very much for inviting me again. And thank you very much for making me part of your family, Sakshi family, and doing these shows with me and giving me an opportunity to talk about the immigration laws on Sakshi TV, Andy. Thank you.
Yeah. So, Bhanu garu, manam before we begin this show, please మీరు information law offices and also practice areas మా viewers కోసం.
Sure, definitely. My name is Bhanu Babu Illindra, Andy. I'm an immigration attorney here. I'm practicing for 17 years immigration law in the US. And I started my own law firm in 2008, which is named as BBA Law Group, basically. And we are located in Herndon, Virginia, which is Washington, D.C. suburbs. So basically, we are in Washington, D.C. And we exclusively represent immigration matters, like all types of immigration matters, inbound and outbound, all types of immigration matters, basically. And mainly we represent most of the case in employment-based immigration, family-based immigration, and also EB-5 investor visas and all that stuff. Our firm website, if you want more details about our firm, they can visit our firm website, which is www.bbalawgroup.com. And our office number is 703-496-7722. And our email ID is contact@bbalawgroup.com. So any questions they have, if they want to schedule an appointment private to discuss privately with us, they can always reach our firm, even by going to the website, go to the contact page and schedule a time over there by looking at the slots availability and everything. And they should be able to reach us. Very easy to reach us basically for any questions they have about the immigration laws. Thank you very much for asking me about my firm and everything I did.
Yes, thank you, Bhanu garu. So today's topic is AOS process and the timelines, adjustments of status. So last week మనం GC process and all details కూడా మాట్లాడుకున్నాం కదా. So ఈ రోజు adjustment of status process గురించి తెలుసుకోబోతూ ఉన్నాం. And before we get into the topic, do you have any latest updates on immigration this week, Andy?
Yeah, we have very, very important updates today, actually. Both came actually yesterday. One came yesterday, one came today. But they both were into place yesterday only. First thing is basically, I will talk about the very important thing, which really important to our Indian community, especially for the people who actually file for the adjustment of status applications and everything. The public charge rule, which was implemented by the Trump administration, that forced the applicants to show that they're not likely to become public charge by providing their credit reports, providing their financials and everything, basically, along with the Form 944. They have to submit all these things. It was mandatorily required to file along with the 485. And if you don't submit the 944, they're going to reject your 485 application. And also at the same time for H-1Bs also, you have to say that you're not subject to, you have not taken any public assistance, anything from the government or anything like that. Biden administration actually rescinded that policy. They actually withdrawn that policy to implement. That's a huge, it has a huge impact on people who can qualify getting a green card, who can qualify for H-1Bs or any other work visas in the US, basically. That's a very welcoming news because the burden on the people are beyond preponderance of the evidence standard. Basically, it went beyond clear and convincing standard because showing them that they will never, they were basically never likely to become public charge. Nobody can control what may happen after 10 years, especially with this backlog and everything. It's impossible for every minute to prove that providing their credit reports, providing their financial history, it's not necessarily required for the US government to provide. If they want, they can ask them publicly, whatever is required. Now, it's not mandatorily required. So if anybody is issued any cases that are pending right now, for those cases also, they should not apply this rule anymore. So for example, if anybody gets any RFEs asking about Form 944 or their ability to say that they're not publicly charged, asking their financial tax returns or other documents, anything to be provided, now they have a very good chance to respond to it properly. and I think they should reach the attorneys and take the help of the attorneys on how to respond to these RFEs so that they won't be unnecessarily denied their benefits just based upon the public benefit rule and everything. So that's a very, very important and basically good thing about this is because now you don't have to submit Form 944 with the 485, and you do not have to tick the boxes also in Form I-129. If you don't tick the boxes, they're not going to reject your file, basically. So those are the things which are very, very important with this update which came out today in the morning, basically. And other update is that this is also very important for the Indian community, especially for the children who are aging out, basically, right? I mean, basically, children came here as non-immigrants, as an H4 dependents or L2 dependents, and staying here for a long period of time because they're waiting for the adjustment of status applications to be approved for their families, but they're aging out. They're becoming 21 years of age, so they will lose that benefit and everything. Why I'm talking about this is basically because this is one of the most key parts of the bill that has been passed in the House yesterday in the Congress, basically, where they passed the bill in the Congress, which basically requires, which actually provides path to the citizenship for the people who came illegally in this country and legally in this country. Basically, the requirement is that they need to be physically present in the US as of a particular date. Basically, that's what the requirement is. And if they were, whether they're legal or illegal, they will be eligible to file adjustment of status application in this country by meeting certain requirements, by paying certain penalties and everything, and eventually to gain an age relation, basically. So House passed that one yesterday. It's a completely partisan bill, and it was passed through the partisan yesterday, but the bill is pretty good bill. If the bill is taken by the Senate, and if the Senate can pass the bill, then we can see a lot of movements for the green cards, basically for the individuals. Their dates will become current automatically because they're going to retrieve all the backlog to visas also as per this bill. So there are a lot of good things in this bill. It's just not only for the people who have been unlawfully present in this country or basically came into this country without any paperwork or anything like that. Even for the legal immigrants, there are a lot of good things in this bill. And hopefully this bill will be taken in the Senate, which is very unlikely. As per the experts, it's very unlikely in the Senate this bill will go through because of the filibuster rule which is placed in Senate right now. All the Democrats control the majority in the Senate. Still, that is a problem because it has to be passed by the bipartisan. They have to get 60 votes to pass that bill in Senate, which is very, very difficult as of now by many experts, basically. But we do not know how the things will be in the future. Maybe this bill will be continued like this, or some parts of this bill may be introduced in the Senate. We do not know that. But that's a very good update which we have, which came yesterday, basically. So these are the two very, very important updates which we saw in last 2 days in immigration law. And the one more thing basically is that we all know that we discuss about the visa bulletin dates. The visa bulletin dates are moving forward, basically. They moved a lot this for the month of April. And as per the Oppenheim, it is expected that it's going to move even forward in May and June. That's a very good date because of the still immigrant visas are not being issued at the consulates. These visa numbers are going to be available for the people who are in the US to file for the adjustment of status or to get the green cards. So these are the three important updates we have in this peak period of time since our last call, basically, last show, basically. And that's what it is, Andy. Yeah.
Thanks for the latest updates, Bhanu Garu. And so in today's topic, I just want to know all information about adjustment of status. So adjustment of status ante enti ela untundi evaru apply cheyochu. So first my question is, what is the adjustment of status? Are there any alternatives to AOS?
No alternatives to AOS. Everybody has to go through that if they want to live permanently in the US.
Okay.
Basically, and AOS means, as you know, that it's adjustment of status. What does it mean is basically is that you may have come to America in some kind of a visa status, basically like H1B or L1 or something like that. But you want to, those visas are basically temporary in nature. They're not permanent in nature, basically. They doesn't allow you to stay permanently in the US because there's an expiry date on the duration to which you can stay in this country in those visas, basically. But if you want to stay permanently, I'm sorry, if you want to stay permanently, then...
Yeah. We have a caller, Bhanu Garu.
Yeah, sure, definitely.
Yeah.
Take the call and then I can continue.
New Jersey. Yes. Meena, please go on. Hello? Meena? Yeah, I think Yeah, maybe it's technical error or something. Yes, Bhanu garu, please go on.
Yeah. So the what I'm trying to say is basically with adjustment of status is that if somebody wants to stay permanently in this country and they came in some kind of a visa which doesn't allow them to stay permanently in this country, then they have to file for adjustment of status in the US if they're in the US. So that is what it's called adjustment of status. It's basically you're changing your status from one state to as a permanent resident into this country. It could be from L1, it could be from H1, it could be from O1, it could be from J1, whichever status it is. Basically, from there, you're changing yourself to permanent resident in this country. That is called adjustment of status application. That process can happen by filing Form I-485 with the USCIS in normal circumstances, but certain cases with Form I-360 and other things also. But for that also, you have to file I-485, no matter what, basically. So by filing I-485, only you will be able to adjust your status in this country. That's what adjustment of status is.
Okay. So who can adjust their status? I mean, anybody, or is there any particular criteria for that?
Yes, basically the criteria is, as I said, people who can adjust status in this country are the people either through the family-based immigration, like somebody in the family sponsoring you a green card. Like family means it has to be either your brother or sister, US citizen brother or sister, or your spouse, US citizen spouse, or US citizen husband, US citizen spouse, or basically US citizen parent or a son, basically. They are the ones who can sponsor, or green card spouse can sponsor, or green card parent can sponsor to the children who are unmarried and below 21 years of age, even unmarried son and daughters also. And that's what it is anyways. So there are different categories can be done, and I think we can take the call, Andy.
Yes, we have a caller from New Jersey again, Meena. Meena, please go on.
Yeah, hi. Thank you for taking the call. I'm currently on H4 EAD. To avoid the delays because of in this renewals and stuff, I'm planning to go to India for stamping and get my H4. So once I come back, I'm planning to apply for standalone H4 EAD renewal. So here my question is, after applying for renewal, can I travel to India? Will it cause any problem for the...
Right. You mean to say... No problem for the renewal process. Ma'am, you can travel to India. I mean, applying for renewal of EAD you're talking about, basically. And if you're applying for renewal of EAD, you should be able to travel to India. There should not be any problem, basically. While EAD
will that cause any RFEs or rejection of the standalone H4 EAD extension?
No, I mean, you may get an RFE anytime. Getting an RFE is always a possibility, but they should not deny your standalone EAD if you travel abroad while EAD is pending.
The reason I'm asking is it's based on the I-94, right? So if I travel out of the country, I'm not sure if the I-94 will be valid or not.
The point here is this: when you file for renewal of EAD, whether you have a valid status in this country in the category for which you are seeking EAD or not is what is required. When you're traveling on H4 visa, when you have a valid H4 status, and you file an H4 EAD, it should be pending. They should continue adjudication. You should be able to go and come back, basically, and they should be able to approve your EAD based upon that. Only the time your EAD will be denied, basically, is that if your EAD is based upon the adjustment of status, change of status application. Like, for example, from H1 to H4, you're filing change of status, and that is pending. Along with it, you file H4 EAD. Maybe it's a standalone. You may think it's a standalone because you're filing it separately while your change of status application is pending for H4. And under those circumstances, that that EAD will not be approved, because if you leave, your change of status application will be denied for abandonment. So if you file just for H4 while you're in valid H4 status in this country for H4 EAD extension, while you're in valid H4 status, you come back and you leave the country and you come back on the same status with a new I-94, it's okay. Basically, because when you're coming back on new I-94, still that H4 EAD will be adjudicated normally only. I've never seen, in my experience, those H4 EAD applications being denied or rejected for abandonment.
Right. Thanks for calling, Meena. And Bhanugar, it's time to take a small break. And let's take a small break and we'll be right back. Stay tuned.
Sure, definitely. Right. Wind today, a lot of wind.
Yes, sir.
It's very windy.
Right. Welcome back to our special immigration talk show with attorney Bhanu Babu Illindra garu. So, Bhanu garu, I just want to know, what is the fee of AOS and how to check our status application?
For the green card adjustment of status application for adults, the total fee is $1,225 basically. That includes biometric fee as well as the USCIS filing fee for I-485. It's totally $1,225 as of now. If you're filing for a child who's a minor, below 14 years of age, basically, and you're filing with any one of the parents, basically, then the fee for them is $750. These are the USCIS fees, basically. You have to pay those fees to the USCIS to file for adjustment of status application. The way you can check the status is that, we do not have any particular tool which is really accurate to check the status. But the best way is that you can check the status online. You're on the USCIS website, where you go there, you see the case online status tool, basically, where there you can put your case number, then you can see the case status, what's going on and everything. But the problem with that is it has never been accurate. It is only accurate up to 70% or 80% of the times. Remaining 20 to 30%, it's not accurate. So it's not that every time you get proper updates over there, but that is only the way one can check the status of their cases. There's no other way around.
Okay. So what is the difference between an immigration petition and an adjustment of status?
Immigrant petition means it's actually the one which allocates the immigrant visa for you. That means, for example, if you are coming to green card in this country, there is a visa has to be given to you, immigrant visa, permanent. That's called permanent visa, basically, right? That has to be given to you. In order to give that visa, basically, you have first USCIS has to approve your immigrant petition. That means you have to file a petition for that, and that petition has to be approved. Then the USCIS says that, okay, this guy is eligible to get the immigrant visa. You can issue this immigrant visa. That's what it will tell you basically to the Department of State, because Department of State is responsible to issue these immigrant visas, basically. So USCIS will review the case properly, everything says, okay, this guy's, whatever the benefit this individual is seeking is eligible for the benefit, you can issue the immigrant visa for the individual. That is the actual process of immigration, basically. So, but when the individual who actually applied for this benefit is already in the United States, then what they do is that because you're already in the United States, you can file for an adjustment of status application with the USCIS. USCIS will determine that you are eligible to get the green card or not, adjust your status or not. Because you eligible for immigrant visa, criteria is different, but you adjusting your status in this country, criteria is different. Again, you should not violate any US laws or anything like that to get adjustment of status because you're already in the US, basically, right? Mm-hmm. So that is the difference. So adjustment of status always comes in the later part. Once the immigrant visa petition approves, then the adjustment of status application will be adjudicated. You can file together sometimes, depending upon the visa number availability and everything. But they're not going to adjudicate adjustment of status application without adjudicating immigrant visa petition, basically. Okay? Mm-hmm. If it's a family-based immigrant visa petition, it's Form I-130. You file Form I-130 and everything. If it's an employment-based petition, you file Form I-140, basically. If it's an investor visa, you file Form I-526. And if you're filing as an abused spouse of a U.S. citizen spouse or any abuse or domestic violence spouse, basically, you file Form I-360, which is called American Asian Widow petition, basically. And you file that is also immigrant visa petition, basically, right? So these petitions has to be filed first, though have to be approved. And if they're in the outside of the country, they'll be able to go abroad to the consulate, get visa, and then come back. They have to apply for a visa application just like any other visa abroad at the consulate. They will interview at the consulate and issue the visa for you, through which you come to country, and then you receive your green card in the US. So, but if you're already in the US, then you file for adjustment of status. So that is the process, basically.
Okay, then what is the difference between consular processing and adjustment of status?
As I said, if somebody is in the US already, and they want to become a permanent resident, then you file for adjustment of status application. If somebody is not in the US, they're already physically present outside the country, then they have to go to the consulate and apply for a visa at the consulate, and the consulate has to stamp a visa in the passport, and then they'll come to US based upon that stamp. It's called 551 visa stamp, And once they come into this country, then they get a green card. Then they become a permanent resident. So that is what is called consular processing. Consular processing is they go to the consulate, get visa stamped, and then come to the US as a permanent resident.
Okay, now I got it. So what is a concurrent filing?
Concurrent filing, as I said, it's a term which is used when you file for the immigrant visa petition and adjustment of status together if the individual is already physically present in the US at the time of filing the petition, provided their visa numbers are available as per the per country limitations, which we talked many times in the past shows basically. And if that is available, then they can file concurrently I-130 and 485, or I-140 and 485, or that's where it is. Not everything, every petition is allowed to file concurrently. Every category is not allowed to file concurrently. Only certain categories are allowed to file concurrently. That is basically I-130 and 485 can be filed concurrently for the immediate relatives, because if they're US citizens spouse or US citizen parents or anything like that, or US citizen children also, basically they can file immediately. So they can file I-130, 485 concurrently. Same thing with the I-140 and 485 also. If the visa numbers are available, they can file concurrently. When they're filing immigrant visa petition and the adjustment of status application together, then it's called concurrent filing, basically.
Okay. So where should we file our adjustment of status application? Same as USCIS or somewhere?
It's with USCIS, basically. But it depends upon which service center. It all depends upon where you are residing and what service center has a jurisdiction over you. You have to file your application with that service center, basically. But that's a USCIS service center.
Okay, Bhanu, so my next question is, does travel outside the United States affect our permanent residential status or not?
It all depends upon it. I mean, how long you're traveling outside the country, basically. That makes a very difference in order to impact your permanent residency. If you're traveling for a long period of time outside the country, but you're using green card only to come to the US and go, then that's going to impact your green card, because that means you're not permanently residing in the US, but you're residing somewhere else, basically. And so it's always, if you travel more than 6 months, basically, any time while you're on the green card, and if you stay outside the country for more than 6 months while you're on the green card, always there is a presumption, basically, saying that he might have abandoned his permanent residency. That means he's no longer intended to continue to stay permanently in the US, basically. So it's always risky if you travel more than 6 months on a continuous period of time on a green card, unless there's circumstances. But always, I would always advise never travel more than 11 months in any year on a green card. Basically, if you travel, there's always a presumption that you are basically not intended to stay permanently in the US, but you're intended to stay somewhere else, basically. So that is a risk when you travel on a green card. But if you travel temporarily for 10 days, 15 days, or 1 month, 1.5 months, it should not be a problem, basically. But that doesn't mean that every 1 month you come here, stay for 10 days and then go. Every month come here and stay for 10 days and go. You can do that legally. This says that you cannot. But you may end up paying taxes in both countries, in the US and in the other country also, if you're working and everything. And there are several things which you have to make sure that you're continuously maintaining valid legal status in this country. Officers can question you at the time, at the port of entry, all those things. So keep that in mind. If you have a green card, don't travel for a long period of time. If you want to travel a long period of time, better to take a consultation from an attorney, talk to an attorney, and see basically what are the steps can be taken, so that you can preserve your permanent residence in the US.
Yes, definitely. So, Bhanu, what can you do if our adjustment of status application is denied?
You always have a remedies, basically, when you have a due process, that is called due process, right? You have an appellate process, basically, right? If your adjustment of status application is denied, you believe that it was denied erroneously, then you should be able to file motion to reopen, reconsider, basically. And even if the motion to reopen, reconsider also may not be futile, basically, then maybe you may be able to file a lawsuit in the courts, basically, depending upon whether such a denial results in the APA violations, Administrative Procedure Act violations or not. And if it is, then you can file a lawsuit also in the courts and litigate on that also, basically. So there are remedies available for that. And first of all, we need to find out exactly what is the reason why and what is the reason the adjustment of status application has been denied first. Without knowing that, it's impossible for us to even to determine why they've denied everything like that. You know?
Yes, right, Bhanu garu. We have a caller from Chicago. Krishna, please go on.
Yeah. Good evening, sir. Good evening. Hello.
Good evening.
Sir,
Good evening, sir. I can hear you.
I have one question, sir. Actually, I have a H1 in 2017, sir. After that, I went back to India in 2019. And also, I have a B1 visa. So right now, I'm in ES on B1 for a client visit purpose. So one of my friend employer wants to file a H1 on cap exempted. So is it any issue change of status from B1 to H1 in future, sir?
It depends upon this. I do not know the complete facts of the case. In general, it should not be a problem changing status from B1 to H1B, basically. Okay? If you're eligible for H1B visa, they should be able to approve your H1B visa. It should be change of status. But obviously, we have to assess on case-by-case basis and see basically if there are any issues while you're coming on a B1, B2 visa here and then changing your status to H1B visa. And also, how long ago you came on B1, B2 visa, and when you are filing change of status, it's also a change of status to H1B also plays a role whether you're eligible for H1B or not. As per the facts, what you're telling me, you are exempt from H1B cap, therefore, you can file for H1B change of status any time in this country. And by coming on B1, B2 visa and filing H1B change of status is not prohibitive in nature, basically. Although it's not encouraged, but it's not prohibitive in nature. It happens many times. People come on a B1, B2 visa for the job interview purposes over here. And once they get selected in the job, then they can actually, their employers should be filing H1B change of status. That's absolutely legal and it's allowed, basically. You know, if anybody says any otherwise, I'm very happy to discuss with them for a long period of time on that issue, basically. Because the purpose of getting a visitor visa for a job interview is absolutely permissible reason to enter on a B1, B2 visa in this country. Or taking an admission into the school also, for that reason also, or considering the schools or some other business opportunities, it's absolutely legal coming into this country. If that business opportunity basically fruitions for you to get a job in this country, and if that employer is willing to file for H1B for you, you should be okay.
Right. I think it's time to wind up the show, Bhanu garu. Thank you so much for joining us. Thank you.
Oh, it's my pleasure, and thank you very much. And for inviting me show again this week also, and making me part of the Sakshi family. And now I strongly believe that I should, when I'm in India, I should go and meet the entire Sakshi team over there for giving me this hospitality and everything. And sincerely thank you. Sincerely thank everyone who's behind the camera and who's behind this particular show and everything. And thank you. Thank you very much.
Thank you, Garu. We'll be right back with another episode of Immigration Show with attorney Bhanu Babu Illindra garu. Thank you so much for joining us. Stay tuned. Namaste.